When the judge held the ring up under the courtroom lights, the entire room went still. It was 10:17 on a gray Thursday morning in Mecklenburg County, and even the bailiff stopped moving. On one side of the courtroom sat 78-year-old Harold Bennett in a borrowed navy blazer, shoulders folded inward, hands trembling in his lap. On the other sat Danielle Mercer, a real estate broker with a six-figure Instagram brand, two attorneys, and the expression of someone who had spent most of her life assuming the room would bend her way. Then Judge Elena Worth looked over her glasses and asked a question that changed the temperature in the building. "So you're telling this court," she said, turning toward Mercer, "that Mr. Bennett stole a diamond from this ring, after you had already filed an insurance claim saying the entire ring was unrecoverable?" Nobody spoke. You could hear the air conditioner clicking in the wall. You could hear a reporter uncapping a pen. You could hear Mercer's attorney whisper, "Don't answer that yet," but it was already too late, because what had started as a story about an elderly man returning a lost diamond ring was no longer about lost property. It was about greed, performance, and the kind of arrogance that only collapses when the paperwork arrives in the right order. And once that order was established, the whole case changed. Harold Bennett found the ring at 6:40 in the morning on April 14, 2025, in the parking lot outside a Publix in South Charlotte. It had rained overnight. The asphalt was still wet, the painted lines shining under a pale sunrise, and Bennett, a widower and retired school maintenance supervisor, was doing what he did 3 mornings a week, collecting aluminum cans on his walking route to help cover medication and utility costs. He was not hunting treasure. He was looking down, because that is what people his age learn to do when every dollar matters. The ring caught the light near the curb by the handicapped spaces. At first he thought it was costume jewelry. Then he picked it up, wiped it on a handkerchief, and realized the center stone was real enough to make him uncomfortable. He walked it inside, asked for a manager, and when nobody claimed it after 20 minutes, he left his name and home number with customer service and headed back to his apartment. By noon, Danielle Mercer had him on the phone. She sounded relieved at first, emotional even. She said the ring was custom-made by a jeweler in Charleston for her 10th wedding anniversary, though by then she was already divorced. She said it was worth well into 6 figures. She said it had enormous sentimental value. Harold, who had lost his wife Carol 3 years earlier, understood that kind of attachment immediately. He told her he would bring it to the store lobby at 2 p.m. so she could pick it up safely in public. That should have been the end of it. It wasn't. Because the second Mercer saw the ring, gratitude disappeared. According to surveillance audio later pulled from the store's security system, her first words were not "thank you." They were, "What did you do to it?" Harold looked confused. The manager stepped in. Mercer began insisting the center diamond looked smaller. Then she said one prong was bent. Then she said the band had scratches that weren't there before. Within 3 minutes, she was demanding Harold explain where the original stone was, why the setting looked altered, and how long he had kept it before deciding to return it. He kept saying the same thing. "I found it and brought it back." Mercer didn't stop. She called police from the parking lot. She told responding officers the ring had been tampered with. She said the man who found it had likely removed the original diamond and replaced it with a cheaper stone. She used the word scheme. She used the word theft. And because the ring was expensive, and because Harold was old, poorly dressed, and visibly shaken, the moment tilted exactly the way moments like that often tilt. An officer asked him to sit on the curb while they ran his ID. People stared. A teenager across the lot recorded part of it on a phone. Harold wasn't arrested that day, but the damage was already underway. Mercer posted online that a Good Samaritan story had turned criminal. She never used Harold's full name, but she used enough detail for neighbors to identify him. By the end of the weekend, strangers were calling him a thief in local Facebook groups. Someone taped a handwritten note to his apartment door that read, "Return what you stole before God punishes you." If you appreciate stories where power finally meets consequences, stay with me, because that was only the surface. The first real crack appeared 3 days later when Mercer filed a formal civil claim demanding $38,000 in damages for loss of stone value, repair costs, emotional distress, and temporary deprivation of property. That number alone raised eyebrows. Her own filing valued the original ring at $82,500, but she wanted immediate damages from a retiree living on Social Security before any lab report had confirmed a stone swap. Then came the insurance angle. Mercer had also submitted a claim to Atlantic Heritage Mutual, listing the ring as lost and presumed unrecoverable. On its own, that wasn't unusual. People do that all the time. But the timing mattered. Her claim was filed at 9:12 a.m., nearly 5 hours before Harold handed the ring back to her in the store lobby. That meant she had already represented the ring as gone, permanently gone. And still, after getting it back, she pushed the theft story anyway. Harold would have been crushed under that machine if not for one person. Assistant Public Defender Lena Ibarra, 34 years old, meticulous, underpaid, and allergic to entitlement. She took one look at the sequence and understood the case was not about jewelry. It was about leverage. Somebody with social clout and legal resources was trying to turn confusion into money, and an old man had been selected as the easiest target. Ibarra started where disciplined people always start. Not with outrage, with records. She subpoenaed the public's footage. She pulled Mercer's insurance submission. She got the intake notes from the insurer. She located the original Charleston jeweler, whose records showed the ring's center diamond had a microscopic laser inscription on the girdle, AHM 4047C. That inscription could only be seen under magnification, but if it was still there, the theft claim would collapse instantly. Mercer's attorney pushed back hard. They argued the ring needed private examination. They argued chain of custody. They argued the old man's possession created substantial doubt. It almost worked. Then investigators found the detail that changed everything. The store's security footage from 1:57 p.m. showed Mercer arriving early for the handoff. She was not crying, she was not frantic, she was sitting in her car, sending messages. A forensic extraction of her phone later recovered one text to her assistant at 2:01 p.m. "If it's damaged, we push. If it's not, we still push. He had possession." That line stopped being ugly and started becoming evidence. By the time the hearing opened in June, the gallery was full, partly because the clip of Harold on the curb had circulated online, partly because local media had started asking why a wealthy broker was trying to collect from both an insurer and a pensioner, and partly because people know injustice when they see it, even before they know how to prove it. The center of the case arrived in a plain, padded evidence envelope. Inside was the ring. Alongside it, a jeweler's lab report from Charleston. Under 40x magnification, the inscription was visible. AHM 407C. The original stone was still in place. No replacement, no swap, no missing diamond. Minor abrasions on the band consistent with contact against pavement. One slightly lifted prong consistent with impact during a drop. In other words, exactly what happens when a ring falls off a hand in a parking lot at dawn. Mercer's whole theory died in a paragraph, but Judge Worth was not finished, because Ibarra had one more exhibit, the insurance call transcript. In it, Mercer stated clearly and twice that the ring had most likely been swept into a storm drain or picked up by someone who won't return it. Then, less than 5 hours later, after getting the ring back, she demanded cash damages from the man who did return it. When the insurer placed the claim on hold pending litigation, she increased her accusations. When the lab report contradicted her, she claimed she had been emotionally overwhelmed. That was when the court turned, not slowly, completely. Judges see fear every day, they see confusion, they see people make bad decisions under stress. What they do not tolerate well is calculated dishonesty dressed up as victimhood. And once the text messages were read aloud, once the timeline was fixed, once the laser inscription made the facts undeniable, Mercer stopped looking wronged and started looking predatory. Ibarra asked only one question on redirect. "Mr. Bennett, when you found the ring, what did you hope would happen?" Harold swallowed hard. His voice was barely above a whisper. "I hoped somebody would get back what they lost. There are moments in court when the law and morality lock into the same place. That was one of them. If you believe no one is above accountability, subscribe, because what happened next was the part Mercer never saw coming. Judge Worth dismissed the claim with prejudice. Then she referred the matter to the district attorney for review of attempted insurance fraud and false reporting. She ordered Mercer to reimburse Harold Bennett's legal costs, pay sanctions for bad faith litigation, and issue a written public retraction within 14 days. Atlantic Heritage Mutual opened its own fraud investigation the same afternoon. Her brokerage placed her on administrative leave by Monday. 2 luxury developers quietly removed her from pending listings within the week. The financial damage was immediate. The reputational damage was worse. But the real collapse happened in the smallest details. The comments turned. The same audience that had once boosted her polished image now replayed the surveillance timeline frame by frame. People noticed how quickly she escalated, how confidently she accused, how easily she weaponized appearance, status, and public sympathy against a man who had done the right thing. And Harold? He went home to a second-floor apartment with aging carpet and a kitchen table scarred by years of use. Reporters asked for interviews. He declined most of them. He accepted one, only to say he wanted people to stop sending money and just think twice before calling a person a criminal. It was the kind of line no media coach would write because it was too simple, too decent, too real. The county later gave him a Civic Honesty Award. He almost didn't attend because he didn't own a suit that fit. That is the thing about stories like this. They are never just about one ring. They are about who gets believed on sight. They are about how quickly wealth mistakes itself for truth. They are about the people who think possession of a microphone, a lawyer, a polished image, or a title means they can rearrange reality and force someone smaller to carry the cost. Mercer thought she was dealing with an old man who would fold. What she was really dealing with was a paper trail, a disciplined defense, and a judge with no patience for manufactured innocence. By the end, the ring itself almost didn't matter. The diamond was still there. The gold could be polished. The prong could be repaired. What could not be restored was the illusion Mercer had lived inside, the one where accusation itself was enough. If cases like this make you think, let me know in the comments. Because the image that stayed with people was not the ring under the courtroom light. It was Harold Bennett leaving the courthouse after the ruling, moving slowly down the steps, one hand on the rail, blinking into the afternoon sun while cameras turned away from the woman who had tried to bury him. She had everything designed to make the world trust her. He had only the truth. And in the end, that was the one thing the court could still recognize on sight.